Hi, and welcome to today's session. We are going to be discussing the review of the Matrimonial Property Act today. My name is Kineile Mabapa. I am an attorney who is in private practice. I have my own law firm based in Polokwane, but operating throughout the country. I'm also the author of a book entitled Before, During, and After the Wedding, which is a book that talks about the legal aspects of marriage in South Africa. As I indicated today, we're going to be talking about the review of the legal aspects of the Matrimonial Property Act. The South African Law Reform Commission has actually asked all of us, me and you, to make comments on the law as to how we would want the law to be like. We need to be able to tell them what are the challenges that we are experiencing or have seen other people experiencing, and make our inputs into that. So what I have done is just to compile a summary of the document that they have put out, so that we can be able to discuss. I thought we would be able to do everything today, but as I was preparing, I realized that we will not be able to handle all the topics today. It would just be too much. So I've split it into two. And I'm thinking that the other session we will do tomorrow. Unfortunately, the deadline is the 14th of January, when we have to submit our comments to the South African Law Reform Commission. I've sort of asked to send mine a little bit later, but we still have to be able to do a bit of work and send through. I'm going to ask everyone to please mute yourselves so that we do not have disturbances during the session. I may just as well check my phone to see if I'm also muted. Okay, so I'm hoping that at the end of the session, we'll have a bit of time when we will have inputs. If you have questions to ask, if you have comments to make, let's be able to do that. So I'm going to start with the session. How is it that we are now being asked to make comments on the matrimonial property law? This is a process. It started quite a while back with the Commission on Gender Equality raising a number of concerns. There has also been attorneys who have raised concerns about the applicability of the law. And we've had a number of court decisions wherein some aspects of the laws related to matrimonial property or to marriage have been found to be unconstitutional. You will recall just yesterday we were discussing the case of Buanya versus the Master of the High Court, wherein the Constitutional Court has found certain provisions of the Interstate Succession Act and the Maintenance of Surviving Spouses Act to be unconstitutional. So there is generally a need for equity and fairness, and also to ensure that there is no discrimination based on gender, race, religion, or marital status. So hence, there has been now an effort to ensure that we look at the laws as they stand in the country. You will also recall that last year we were looking at marriage laws, because we have different laws that pertain to marriage. So our country is looking at unifying those laws and making it just one law. So before I start, I just need to indicate that the review does not look at some aspects pertaining to marriage. For instance, it does not address the issue of children, because there is a law that deals with children. It also does not address the issue of maintenance. However, it addresses quite a number of things. And all of those things are falling under matrimonial property law. So it looks at, I'm just going to list them before I get into the discussion. It looks at the default matrimonial property system. We know that in South Africa, you either get married in community of property or out of community of property. And the default system is in community of property. Anybody who does not have an antenuptial contract when they get married, it means that their marriage is in community of property. That's the status currently. It also looks at deviations from the status quo, because if people do not want to get married in community of property, they have to enter into an antenuptial contract. And there's other provisions where people meet and discuss, come to an agreement as to what they want to see happen, especially when they are married and also at the time when they divorce. It looks at customary and religious marriages. We know that we do not only have civil marriages in South Africa, but we also have customary marriages. We also have religious marriages. It looks at foreign marriages. Marriages between South Africans and non-South Africans, and marriages between non-South Africans who happen to get married in South Africa. It also looks at life partnerships, what we call putative marriages, and the management or mismanagement of assets during the time that people are married, as well as a number of issues on divorce. So today we're going to discuss all of these things except the last two. We're not going to be discussing the management or dissipation of assets during marriage. We will also not discuss technical issues at divorce. I am going to ask you to make your inputs in terms of whether we need to have a session tomorrow or whether we can have a session next week to finalize it. But I think tomorrow would be the best time to do so. Okay. Now, we're going to look at the default matrimonial system. As I've already indicated, if you're getting married in South Africa and you do not have an antenuptial contract at the time of your marriage, then it means your marriage is in community of property. If you want it to be out of community of property, you have to make sure that you enter into an antenuptial contract. And again, with your antenuptial contract, you either get married out of community of property with accrual or without accrual. Now, what the South African Law Reform Commission is asking us as citizens, as people living in South Africa, to say, is it necessary for us to have the default system or not? If you feel that all marriages should be in community of property or all marriages should be out of community of property or have an alternative, you are asked to make an input in terms of what our law should look like when it comes to the system, whether it's in community or out of community of property. Now, as I've said, we have marriages wherein South African citizens get married to foreigners. We also have situations where foreigners come into South Africa and they get married. So you might find that somebody is from a neighboring country, Zimbabwe, and he falls in love with a fellow Zimbabwean, but they're living in South Africa and they marry in South Africa. We then have marriages between people from different nationalities. For instance, you find I am a Black person, I meet a white man, we fall in love and we get married. So we need to look into that. At the time that this law came into effect, that was My apology for that. It seems as if we're having challenges with the Wi-Fi where I am. I'm hoping that it will not disturb us again, but if it does, let's just be patient. Okay. We also have couples who are married. They are South African, but they do not share a matrimonial home. And this is a challenge that has been there for years and years. You would find that I am married. I live in Polokwane, but my husband lives in Pretoria. Not because we don't want to live together, but because mainly for economic reasons. You might find that I have a job in Polokwane and my husband has a job in Pretoria. Okay, so this also causes complications, especially when people get divorced. You might find one person's feeling that, you know, we didn't live together as husband and wife. And now it becomes a challenge because this person says, I don't want to share assets with my spouse because we did not live together. Okay. Now, the other thing that we have in South Africa is a thing called domicile. Domicile is where you have your permanent home or what you consider to be your permanent home. It might be, for instance, that I'm South African, but I go and live in America. After a few years, I feel that America is my home, and then my domicile becomes that of America. So if you are domiciled in that particular area, then it means the laws of that area where you are applicable to you. So in South Africa, you all know that this is a democratic country, men and women are equal. However, there is one challenge. We still, when it comes to domicile, when you get married and you are a woman, the consequences of your marriage are determined by the domicile of your husband at the time that you got married. For instance, if I meet a Zimbabwean man, for instance, we fall in love, we get married. What our law says is that, and sorry, the man, he lives in South Africa, but he still considers Zimbabwe as his permanent home. Our law says my marriage to my Zimbabwean husband will, the law that will be applicable is the law of Zimbabwe, not the law of South Africa. Simply because I am a woman and the law says as a woman, my domicile follows that of my husband. And this gives a bit of challenges for South African women who find themselves married to men who are not South African. Because when they get married, they believe that because they're getting married in South Africa, South African law applies, only to realize when the marriage ends that it is not the law of South Africa that applies, but it's a law of a foreign country that applies. And it might be, for instance, remember I said, when we get married in South Africa and you don't have an antenuptial contract, your marriage is automatically in community of property. So you might be married thinking you're married in community of property, only to realize at the time, maybe unfortunately you get divorced, only to realize later on that your law, the law that is applicable is a law of a foreign country, and that foreign country, they are actually, what's this? The default matrimonial system is a marriage out of community of property. So those are challenges, some of the challenges that we are having. And the other thing is you have people who travel. There's couples, South African couples, they find, one of them finds work overseas, or both of them find work overseas. They uproot themselves, they go and live there. Okay, maybe they divorce whilst they are outside of the country. Those are challenges which law is applicable. Now, the other thing is we have, it's very clear if the marriage is a marriage between a heterosexual couple. But if it is a couple, same-sex couple, now the problem becomes, which domicile do they follow? If it's two women, which domicile would they follow? If it's two men married to each other, which domicile would they follow? Because the law says the woman follows the domicile of the husband. And these people, you would find that they do not fall within the category. So those are aspects that, some of the aspects that we are expected to comment on. Some of us find ourselves in the same situations that I have talked about. Then there's other challenges that we have, because remember, we have different laws. You will find that what applies, for instance, to civil marriage does not apply to a customary marriage. Okay. What applies to a polygamous marriage does not apply to a monogamous marriage. And the different laws also have differences when it comes to age, as to who can get married. For instance, when it's a customary marriage, the couple has to be above the age of 18. But if it's a civil marriage, they can be below the age of 18, so long as there's consent from the parents. Okay. We also have other laws which affect the matrimonial consequences of marriage, like your Pension Fund Act, the tax laws, and insolvency law. Pension Fund Act, for instance, although it's not a matrimonial law, it is applicable because when people divorce, for instance, the law, the Divorce Act says, when you divorce and you're married in community of property, you share 50% of each other's pension interest. Now, as I've said, the default system is in community of property, but we are allowed to change the default system to decide before we get married that no, we don't want marriage in community of property, we want a marriage out of community of property. So we can have an antenuptial contract. It also has its own challenges. It is not the only one, but you'll find, yesterday we're discussing life partnerships. You find people deciding we don't want to get married, but we will cohabit. Now, yesterday, again, I explained the difficulties, because when it comes to life partnerships, there's distinctions. There's a life partnership, and there's a life partnership where the couple has undertaken the duty to support each other. So we don't know basically what is going to be happening with life partnerships where people have not undertaken the commitment to support each other. Okay. And sometimes what happens is when marriage ends, remember, for instance, your marriage in community of property, the law says when the marriage ends, you share everything 50-50. But there is nothing that stops the couple from deciding, coming to an alternative agreement where they don't necessarily share 50-50. It's possible for people to say each one keeps their assets. And sometimes they can share assets, but then they say each one keeps their own debts and they pay their own debts. They don't share debts. Now, when it comes to antenuptial contracts, currently we have a situation where the antenuptial contract has to be notarized. A notary has to be involved in the attestation of an antenuptial contract. And our law doesn't say that the people who are entering into an antenuptial contract should each get independent advice. So what normally happens is that, for instance, I'm a notary. When people want to get an antenuptial contract, I ask them to come in as a couple, and then I explain what the different types of marriages. I explain the different types of marital systems to them. I also explain what happens in the event of divorce, what happens in the event of death or insolvency, and a whole lot of other things that I explain and help them to come to a decision as to what needs to happen. However, there are notaries who do not do that. You know, I've seen adverts where people are advised to complete forms. They send them to the notary, and the notary drafts the antenuptial contract for them. There is no explanation as to what is involved in the antenuptial contract and what it means. So what was this? There's also another challenge where you find that people enter into antenuptial contracts, but their antenuptial contracts do not meet the formal requirements. And now the issue is, can this be valid? The antenuptial contract that they entered into, can it be valid against a third parties? Currently not. Okay. It's the situations where you find the antenuptial contract is unregistered. The law says your antenuptial contract has to be registered within 3 months of signing it. Sometimes you find that they are not, the contracts are not registered, maybe because the attorney forgot to register or for some other reason. Okay, I know I've dealt with situations where I've had to make an application to the court to ask the court to register, for permission to register the contract post-nuptially. Okay, and it gets a bit expensive when what happens. So what the Law Reform Commission is asking us is, should it still happen that the antenuptial contract, for an antenuptial contract to be concluded, the couple have to appear before a notary? Should they use one notary, or should they get independent advice? You find the woman goes to one notary or attorney, the man goes to the other. Okay, and one might say, why such a question? If you look at the practical implications, it happens sometimes that and I'm not saying this is always the situation, but in my experience, I've found that you will find the man goes to an attorney, they draft the antenuptial contract, and then he gives to the woman to sign. I know I had a client, for instance, who only discovered that she's married out of community of property when they were having a fight with the husband and she was considering divorce, and the husband was saying, well, you can leave, but just know that you will get nothing from all the assets, because the assets were registered in his name. She never took interest in the finances of the family, and only discovered at that stage that she was married out of community of property. She signed a document without reading, without an explanation. Okay. And there's been cases where people have actually gone to court and asked the court to declare the antenuptial contract invalid because of the fact that either it was signed out of duress or it was signed out of ignorance. There was no discussion. So hence these questions, whether you need to have these people at the same place or not. The other question that the commission is asking with regards to antenuptial contracts is, should lawyers explain the full consequences of the antenuptial contract? You know, for instance, talking about the death, what happens at death, what happens at divorce. So it's something that we need to consider and make our inputs on. Now, remember I said sometimes at divorce, when people are married in community of property, there's deviations. And one of those deviations is redistribution. Redistribution of assets applies to marriages which were entered into before a certain period. For instance, if it's civil marriages, those were before marriages entered into and marriages out of community of property entered into in pre-1984. Okay. Now, marriages between Black people, civil marriages between Black people, those would be marriages entered into before 1988. And again, we have another category of marriages where marriages were entered into in Transkei, the former Transkei homeland. Those that were entered into before 2000. It is in those marriages where there is a possibility that people can ask for redistribution of assets. The reason is that it makes provision for fairness, because if you are married out of community of property without accrual, because accrual only came into effect, I think, 1984. Before then, if you're married out of community of property, with what it meant is that what you bring into the marriage does not form part of the marriage. What you acquire during the marriage does not form part of the marriage. When the marriage ends, everybody lives with what they own. If you have not accumulated anything during the course of the marriage, tough luck for you. And this created a lot of problems, especially for women. What used to happen in the past, we all know, men were the ones who went to work. Women were mostly stay-at-home moms, taking care of the family, taking care of the children and the husband. And their husband would be the one that brings in the money. And added to that was the problem where men had marital power over women. So even if a woman worked, she did not have control over her own assets. The husband had control over her assets. He could decide to sell her home, he could decide to sell a car, or do anything with the assets, because women were regarded as children. It's only recently that the marital power was done away with. So what would happen is that when people are married out of community of property, the man would acquire assets in his own name. The woman would be doing her share of the marriage. But when it comes to the end of the marriage, when we look at the assets that the parties have, the woman would have nothing when the man has everything. So the result would then be that the man would then have all the assets and the woman would have nothing. And that was not fair, because in most cases, especially for those men who had businesses, you would find that the woman is working in the business, is not getting paid. She's working, it's their business as a family. You would find that the man is successful partly because of the efforts of the wife. But when the marriage ends, the wife is left with nothing. So that is why there was that part that talks about redistribution. And it would happen that when the parties divorce, the woman would then ask for a redistribution of the assets. So, but then she would have to prove that she, contributed directly or indirectly to the maintenance or increase of the estate of the husband. Okay. So now the question is it should we have a continued situation where it's only those people who got married before 1984, or if it's white people, if it's Black people before 1988, and if it's Black people who got married under customary law in Transkei before 2000. Okay. And when it's Muslim marriages, there's absolutely no discretion. Okay. So should we continue having these discrepancies, or should there be a change to have redistribution for all the marriages that were entered out of community of property without accrual, or have alternatives. So it's something that to think about and actually make your input into. Okay, and also looking at what are the factors that the court needs to look into when exercising its discretion, whether to give a redistribution or not. Okay, remember I said under current law, the court looks at whether the person who's claiming redistribution has contributed directly or indirectly to the growth or maintenance of the estate of the person they're claiming against. The other question that needs to be considered is whether your non-financial contributions, like raising children, taking care of the home, should be considered when a distribution order is made, or only the financial aspects of it. Okay. So then there's also the other issue that we're looking at. It's called forfeiture of benefits. Forfeiture of benefits applies especially to people who are married in community of property and those who are married out of community of property with accrual. What happens is that sometimes it might be the 50-50 allocation might be unfair. So a party who feels that the other party would be unduly benefited if they share 50-50 of the assets would then, during the divorce, would then need to make an application to the court and say, I am asking that my husband or my wife forfeit the benefits of the marriage. And normally what happens is the benefits, it's the benefits of things that the person who's asking, say for instance, it's the husband who wants the wife to forfeit. Then the husband will say, I brought XYZ into the marriage, so I'm asking that my wife does not get 50% of XYZ. Okay. Or I'm asking that she does not get 50% of my pension. Now, there's three factors that the court needs to look into if we're looking at forfeiture of benefits. One is the duration of the marriage. How long did the marriage last? It's easier to get a forfeiture of benefits if the marriage lasted maybe 6 months, 1 year, 2 years, blah, blah. But the longer the marriage lasts, it's a bit of a difficulty. So that's the number one. So the first factor. The second factor is what led to the breakdown of the marriage. The third factor is who of the two parties was, for lack of a better word, was to blame for the breakdown of the marriage. So the three factors do not all have to be present for a forfeiture to be given. At least one of them has to be present for a forfeiture order to be given. It's not an order that can be given willy-nilly. There has to be factors that have to be proven in order for the presiding officer, the magistrate, or the judge to ultimately come to a conclusion that this party is not deserving of the 50% share in the marriage. And it's up to the court to decide whether they're saying it's complete forfeiture or a certain percentage of the forfeiture. The other thing to consider is that a person cannot forfeit what they brought into the marriage. So you cannot ask if say for instance, you found me owning a house, you did not contribute anything the bond or anything, you just found a fully funded house with furniture and everything, and I'm asking for forfeiture of benefits. I can ask for forfeiture of benefits, but if I married you and you did not contribute to the house, you cannot ask that the court make me forfeit the house that I brought in because it's mine. I brought it into the marriage. Okay. So now the what we need to consider to make inputs on is whether the forfeiture needs to continue, and whether it shouldn't be made possible for a person who has brought something into the marriage to actually forfeit. And whether it should always be these three factors, one of these three factors that I talked about, we should be applicable, or there could be an addition of factors that could be looked into. So now, one of the things that has happened when research has been done, I think it has become clear that the issue of forfeiture of benefits has a bit of gender discrimination within it, because of the fact that women, in most instances, although this is becoming less and less, I think, because women are now working, women are now owning assets. But historically, you would find that men are the ones who are financially stronger, the ones who bring things into the marriage. Now the question is, should we always consider that a person who has brought assets into the marriage cannot forfeit them? You know, maybe we need to look at issues of balancing things between people. Now we have customary marriages. Those who have attended my sessions before, you know, we've talked about the Recognition of Customary Marriages Act. We've indicated that customary marriages are now recognized as marriages in South Africa. So if you're married under customary law, you don't necessarily have to go now and get married under civil law, okay? Because you are married. And you have the same rights and responsibilities as somebody who's married under civil law. Okay. But you have a situation where there's customary marriages, you have monogamous customary marriages, and you have polygamous customary marriages. And there's differences there. For instance, when you have a monogamous marriage and you did not enter into an antenuptial contract, your marriage is automatically in community of property. Now, when it comes to polygamous marriages, the law says if a man wants to marry another woman, he has to get permission from the first wife. That's the one thing. The other is that he has to approach the court and change his marital system. Okay, because quite frankly, we cannot have a community of property of 3 people. Okay. Now, the challenge is that most men who marry a second wife do not approach the court to change their marital system. So they just enter into a polygamous marriage when there is already a marriage that is in community of property. And when there's a divorce, when there's a death, it becomes difficult now to check as to how these assets will then be divided. It's better if there's a death, but if there's a divorce, it's even worse. Okay. And let me just look at this. Okay. Then there's the issue of people who get married in community of, under customary law. You find that during the customary marriage stage, they don't enter into an antenuptial contract, which makes their marriage a marriage in community of property. Then they go and enter into a civil marriage, and they decide to enter into an antenuptial contract. Some of them, they don't explain to us attorneys that they're already married. They tell us they're not married already. And they have the antenuptial contract. Come the divorce stage. Now, the party who is not suited by a marriage out of community of property will start complaining and saying, but my marriage is in community of property. When I signed the antenuptial contract, I was already married and I was married in community of property. Now, that is a challenge, but again, the Recognition of Customary Marriages Act also has a challenge because it makes provision. It says, if you're entering into a monogamous customary marriage and you don't have an antenuptial contract, your marriage is a marriage in community of property. And then it later goes on and says, the very people who married under customary law, they can go and marry under civil law and they can have an antenuptial contract. Okay. We're now having a situation where we don't know what are the implications. I know of 2 cases before the court where people are asking the court to look into that matter. So until it's determined, we don't know what is going on. Okay. So now let me go and talk about religious marriages. I'm not going to spend a lot of time here. Religious marriages are normally your Hindu marriage, your Muslim marriage. Currently, as the law stands, they are not recognized, but our courts have substantially recognized them and made orders that the law should be changed to accommodate the marriages. And you will recall last year, can you please mute yourself? There's somebody who's making noise. We'll remember that last year, when we talked about the contributions to, the marital act, we have indicated that the South African Law Commission is looking into that, and there is a possibility that religious marriages would be recognized legally. Okay, there's attempts at making that possible. However, there is a type of religious marriage that I want to talk about, which is problematic, which is a Christian marriage. We know there are churches that promote polygamy in South Africa, and often you find that men who are in these churches, their first marriage is a civil marriage. And then whilst they are still married, they meet somebody else and they decide they want a second wife. And they go on and marry at church. Our law says a civil marriage cannot coexist with any other marriages, which would basically mean that the second marriage is invalid in the eyes of the South African law. Okay. But we know, all of us know, people who enter into these marriages. It happens every day. Okay. So we don't know what the status is. If I'm looking at it at a purely legal, with a purely legal eye, the marriages, the second, third, or fourth marriages are invalid, basically because of the fact that the civil marriage cannot coexist with any other marriages. Okay, so now there's questions. Question is, what matrimonial property regime should apply to religious marriages? And how can we deal with the challenges? The churches that I'm talking about, I think Kreke Tate Modise is one of them. If you are a member of that church and you are under this situation, surely you have an input to make as to how your situation can be dealt with, so that In the event of challenges, for instance, like a person, the husband dying, you don't find wives, having problems. Now, somebody is saying they're in the meeting and they can't hear a thing. I think it could be a problem with your computer. Check your settings. Now, we also have what we call putative marriages. Putative marriages is marriages that were entered into with at least one person believing that the marriage is valid, only to find that it is not. I'll give an example. I meet James, we fall in love. James doesn't tell me that he already has a wife and he got married under civil law. He then decides that he is going to pay lobola for me and he is going to marry me. And I enter into that marriage thinking I'm the only wife, whereas I'm not. So that would be a putative marriage. Or it would be that we know that we are not allowed to marry our brothers and sisters. Okay, so if I have a brother, maybe my father impregnated somebody and we did not know about each other. The law says we can't get married. We get married only to discover after our marriage that we are related. Okay, that our marriage becomes putative because it was not supposed to happen. It's an incestuous marriage. Okay. Now, okay. My apology again. We still having challenges. Now, the challenge is that, okay. If a marriage is invalid, then what? Okay. Especially if there is a prior marriage, okay, which is a marriage in community of property. What needs to happen? We're supposed to make inputs in terms of how do we deal with this situation? Someone entered into this marriage innocently, either because somebody defrauded them, or they were under the mistaken belief that they could get married, but the law prohibits them from marrying. Currently, if one party was at fault, the one who was not at fault can make a claim against that party. Do we want to see that continuing to happen or not? Or what would we like to see happen? And as to how should the properties be divided amongst the two people. Now, the other challenge that we are having is issues of universal partnership agreements. So where you find that people, the court orders for people who are not necessarily married or to share in each other's estates, okay, because they have a universal partnership. Now, the challenge with universal partnerships is that you need to have entered into the relationship as partners. Each one of you needs to have contributed something into the relationship, and you had an intention to make a profit. Now, the challenges you would find, especially with regards to women, that they do not necessarily, not all of them, they do not necessarily make financial contributions, but they make those contributions which are not necessarily quantified with money, like taking care of the household. If you're taking care of the household, it really cannot be quantified. Okay, if you're taking care of children, which cannot be quantified. So how would then a person who has contributed, but their contribution cannot quantified in terms financially, how do we determine whether this person is in a universal partnership or not? There have been situations where people have asked the court to make a declaration that there's a universal partnership, only to have the court say it's not a universal partnership, but they have contributed to the relationship. So the discussion today is going to end here. And our next, we're going to be talking about the management of assets during the marriage, whether it be the management or mismanagement of assets. Can somebody, whoever is unmuted, mute themselves, please. Sometimes it happens that when people are married, one of them will misuse the funds in the marriage. And if the marriage ends up in divorce and they're married in community of property, then there's the issue of 50-50, whereas the other party has already messed up the assets of the marriage. And you know, there's things like when people are married, they will set up a trust, or one party will set up a trust and funnel funds into the trust. Come divorce time, the party knows that they have these assets, only to realize that the assets are not in their names, so they are not able to claim. Then there's career assets. You know, for instance, you have your legal practice, you get divorced. Remember, 50-50, you have to share. Is it appropriate for people to share career assets or not? Then we have the pension fund. The pension fund, remember, if you're married in community of property or with accrual, your pension interest becomes part of the assets that needs to be shared during the divorce. Should that continue being the case or not? Okay, then there's the issue of family homes. We know as Black people, we always try to ensure that we leave homes for our children, and there's always fights. I know there's even a program specially dedicated for family homes called Kugitila. Yeah, I saw one episode the other time over the festive season, and it was very depressing. Then there's issues of settlement agreements, parties settling and agreeing on things. And that is what we will be discussing during the next session. And I just need to remind everybody that you have a voice and your voice can make a difference. Remember, the law that needs to be changed now, it was developed in the 50s, I think it was 1954. When it first came into effect, I was not born then, but that law is applicable to me. There's been so many changes throughout the process. We know what challenges we're sitting with, and we are giving an opportunity to make inputs into that. So your comments are important and can change things for the better. It's not everybody who has the time to write a long story to the South African Law Reform Commission. But if you have inputs, do not think that your input doesn't matter. If you cannot make inputs directly to the South African Law Reform Commission, please send me a WhatsApp. You can send me an email saying what you think needs to happen, and I will make it my business to incorporate it. I have my own thoughts as to what needs to happen. I will incorporate your thoughts into it and then send it out. If your thoughts are different to mine, in my presentation to the South African Law Reform Commission, I will indicate that this is a comment from somebody else. I might not agree with it, but this is a comment that is sent through from somebody else. For those of you who would want to send me comments, you can send me comments on my WhatsApp number, which I'm typing in now. It's 0768841842, or my email address, which is info@kineilwemababa.co.za. Remember, the deadline is the 14th, so I would appreciate it if you send your comments today and tomorrow, or even on the 14th in the morning. Okay, so tomorrow I've indicated what we will be discussing. I'm asking that tonight, before we sleep, we just think through the things we discussed today. And tomorrow I'm hoping, because we only have 2 issues, although there's a lot of things to be discussed, that we will have time wherein we can, I will open up the floor for you to make your comments, and you can also write your comments. And at the end of the day, we will be able to make inputs to the South African Law Reform Commission. Just to end, I made inputs into the okay, as I was saying, I made inputs into the proposed single marriage statute last year. And, you know, this morning I was talking to somebody at the South African Law Reform Commission, and I was informed that my comments helped tremendously. And it really made my day to know that I can express my opinions, and those opinions can be taken seriously. So if my comments can be taken seriously, I'm sure your comments can be taken seriously. Let's make use of this opportunity, my dear brothers and sisters, and make our comments. As I said, if you cannot make the comments yourself, I'm available. Send me your inputs and I will make sure that they get to the commission. And no comment is a useless comment as far as I'm concerned. All comments are important. So I am suggesting that we meet again the same time tomorrow to finalize what's this? The discussion that we've started on the review of the matrimonial. Okay. All right. So, ladies and gentlemen, let's meet tomorrow. I don't know, unless there's a different suggestion. I'm not seeing any comments on these charts, which would mean that you are in agreement that we'll meet tomorrow at 6 o'clock to be able to look at the challenges with regards to the management of assets during the marriage, as well as the aspects of divorce, like your pension, you know, what needs to happen there. Okay, thank you so much. Goodbye. See you tomorrow.